Welcome to this special edition of the Trinity Chambers Civil Liberties and Human Rights Team webinar series. This webinar has been produced in collaboration with the charity INQUEST, and we have 4 speakers today. Firstly, Jodie Anderson, a senior caseworker at INQUEST, and she will begin by delivering a talk about the vital work done by that organisation. After that, I will be presenting a webinar on the new Judicial Review and Courts Bill and discussing whether it will deliver a streamlined coronial system. Parissa Najah will then address legal aid applications for interested persons at inquests. And finally, Shada Mellor will conclude the talk by delivering a talk about Regulation 28 and reports on preventing future deaths.
Hello, my name is Jodie Anderson and I'm a senior caseworker at the charity INQUEST. I'd like to begin by thanking Chambers for the invitation to INQUEST to speak at this webinar. I'd like to focus on the work of INQUEST and our wider impact and the bigger picture issues facing state-related deaths. INQUEST was founded in 1981 following family campaigns to ensure truth, justice and accountability following state-related deaths. We are an independent charity and the only one of our kind in England and Wales, providing expertise on contentious deaths and investigations. We offer a free specialist casework service to bereaved people following deaths in custody and contentious deaths. We produce evidence-based policy, research and legal work, including parliamentary briefings, consultation responses and press releases, all of which is underpinned by the collective experience of the bereaved families that we work with. INQUEST coordinates the INQUEST Lawyers Group, which I shall speak about, and the Family Reference Group, comprised of families who we work with who advise on our work. The Casework Service provides specialist advice and information to bereaved people on deaths in custody and other state-related deaths, including deaths in a prison setting, police custody or following police contact, deaths in mental health settings, cases involving multi-agency failures, including children and young people, and cases involving state or corporate accountability or large-scale disasters such as Hillsborough and the Grenfell Tower disaster. So how do we work? Well, INQUEST operates a unique and integrated model of working which combines specialist casework, family empowerment, media engagement, policy and parliamentary influencing and campaigning. The Casework Service is the backbone of our organisation. Through it, we are able to identify trends, patterns and emerging themes, such as evidencing the disproportionate use of force against black men by police officers. Last year, INQUEST gave evidence to the United Nations High Commissioner on Human Rights to inform their damning report on racial justice and equality. INQUEST draws on decades of experience working with bereaved families who have lost their loved ones following or during contact with law enforcement agencies in the UK. INQUEST amplifies family voices and experiences, leading to greater scrutiny of deaths and broader inquiries. Take the Angelini Review, for example. In July 2015, in her former role as Home Secretary, Theresa May met with the families of Sean Rigg and Sheni Lewis, 2 black men who died following police restraint in London. Following that meeting, Theresa May announced a landmark independent review into deaths and serious incidents in police custody. The review was undertaken by Dame Eilish Angelini, hence it became known as the Angelini Review. Our director, Deborah Coles, was special advisor to the chair, and INQUEST facilitated meetings for the review to hear directly from bereaved families, as well as from lawyers who regularly represent families. The report made over 100 evidence-based recommendations, including non-means tested legal representation for bereaved families, a national oversight mechanism, and a duty of candour for police forces. The impact of that review is still being felt today, and it truly changed the debate on the issues surrounding deaths in police custody. The Angelini Review is a powerful example of the central role that bereaved families play in bringing about truly transformative change. In addition to our expert evidence, INQUEST also provides witness statements and intervenes in strategic litigation. Key recent examples include evidence given to the Brookhouse inquiry into the mistreatment of immigration detainees, an intervention in the case of Morn in 2020, which changed the standard of proof for suicide and unlawful killing conclusions to the lower civil standard of proof, and the ongoing intervention into the case of W80, a challenge concerning the officer investigated over the fatal shooting of Jermaine Baker. This case concerns an important point about the use of force by an officer and whether misconduct proceedings could be instigated against him on the basis of his honestly held but mistaken belief. I'm going to speak briefly to you about our work on deaths in prisons. But before I do, I want to share with you a quote from a bereaved father whose son died in HMP Chelmsford in 2016. In this country, we do not give the death sentence, but for everyone who has taken their life in prison, that is exactly what they got. By way of context, in 2019, the House of Commons Justice Committee published a withering report on prisons. It condemned prisons in this country as being in the grip of an enduring crisis caused by short-term policy making and a failure to invest properly in improving services. The report highlighted some of the many concerns that we at INQUEST share within the crumbling modern-day prison estate, which provides a very grim backdrop to our casework. It noted high levels of violence and self-harm, chronic overcrowding, squalor, dilapidation, loss of experienced staff, and a surge of spice and other substances. And fast forward to 2021. This time last year, INQUEST predicted in the midst of the second wave of COVID-19 that the worst was yet to come in the prisons. Despite what could have been learned from the first wave of the pandemic, no action was taken, and our fears became a reality. On the 27th of January 2022, just 2 months ago, the Ministry of Justice released their latest statistics on deaths and self-harm in prison in England and Wales. It confirmed that 2021 saw the highest annual number of deaths ever recorded in prisons, 370 deaths. That equates to 1 death a day and 1 self-inflicted death every 4 days. Of this number, 250 deaths were classed as natural causes, though our caseworker monitoring shows that many of these deaths are premature and far from natural, with issues such as lack of urgent or appropriate healthcare repeatedly being highlighted in INQUEST conclusions. In regards to the COVID-19 cases in the prison estate, we see that vulnerable, high-risk prisoners suffer the lethal consequences of a lack of urgent care to safeguard them from the virus. We have dealt with only a very small number of COVID prison inquests in which Article 2 has successfully been engaged, and therefore a broader inquiry carried out. Of the 370 deaths that I mentioned, there were a shocking 86 self-inflicted deaths over the year. That is an increase of 28% from the previous 12 months. These statistics represent the serious consequences of highly restrictive regimes on people's mental and physical health. But the pandemic alone cannot explain away the record number of deaths. The figures reflect the continuation of harmful and dangerous prison systems, inadequate health and mental health care, and criminal justice policies which use prison as the response to a social problem. In September 2019, a female prisoner at Bronzefield Prison gave birth to a stillborn baby in shocking circumstances without specialist medical help or pain relief. 2 years later, in September 2021, the Prison and Probation's Ombudsman published their investigation into that death and highlighted considerable issues and concerns about the care and management of Miss A, the baby's mother. Just 5 months later, in February 2022, the Prison Inspectorate published a damning report into Foston Hall Women's Prison. It identified very high violence and self-harm and inadequate care for women. Whilst we welcome these investigations and their damning conclusions, they echo the findings of previous reviews, such as the 2006 Corston Review of Vulnerable Women in the Criminal Justice System, or our own 2019 Still Dying on the Inside report into the deaths of women in prison. In order for these reports to be impactful, INQUEST calls for a national oversight mechanism with statutory footing to monitor and oversee the implementation of recommendations made in successive reviews and at inquests. Families look to the inquest process to provide a crucial opportunity to uncover the circumstances of a loved one's death, and often in contentious circumstances. It is through the courage of bereaved families in holding the state to account at this most difficult time that we see the same failures identified, missed opportunities, and lessons learnt. In the prison context, we often see noted in conclusions the improper use of segregation, inadequate screening or mental health assessments, a failure to open act or to carry out proper monitoring and observations, poor record keeping, a lack of effective communication between healthcare and prison staff, and the prevalence of drugs and bullying. Despite these challenges that families face by engaging with this process, their primary aim is to ensure that no one should ever suffer the same fate as their relative. As one family said, "As families, we need to try and make our voice heard, because if not, there is no chance things will improve and lives be saved. Just maybe some good will come out of it so that my child and others will not have died for nothing." INQUEST campaigns are grounded in improving the experiences of bereaved families who endure this process. Our key campaign goals are, firstly, public funding for bereaved people at inquests. After 40 years of campaigning, INQUEST welcomes the recent changes, including the removal of a means test in Article 2 inquests. Our second campaign, the National Oversight Mechanism, would see an independent public body with the duty to collate, analyse and monitor recommendations and their implementation arising from inquests. Thirdly, we'd like to see a statutory duty of candour on public officials, otherwise known as the Hillsborough Law. So how can you get involved? INQUEST works closely with legal practitioners in this field. The INQUEST Lawyers Group is a national pool of lawyers that promotes and develops knowledge and expertise in the law and practice of inquests. Membership is open to all lawyers who predominantly represent bereaved families. We provide a space for information sharing, networking and training, policy change and campaigning. And we facilitate key meetings with stakeholders, lawyers, the IOPC, the PPO, the Chief Coroner, the CPS, and so on. Specialist legal expertise of our ILG members is a lifeline to families and a crucial source of knowledge and insight to us. We work with lawyers in a collaborative partnership. We have a valuable organisational memory and national oversight. We add value to practitioners by providing stats, trends and patterns, recommendations on experts, contextual information about particular institutions, policy and practice changes, media strategy and facilitating press interest, past inquest findings and conclusions, and issues for wider policy and influencing work. As part of membership to the ILG, you get access to our very own legal journal, Inquest Law. This is a vital resource for lawyers, coroners, and other stakeholders with an interest in the coronial process. It's published 3 times a year and is written by INQUEST Lawyers Group members and individual contributors. Anyone can subscribe. And finally, the ILO, or ILO, Inquest Library Online, is a searchable online database containing inquest conclusion documents that you have access to. It includes inquests from 2013 to date where inquest was involved, including ROIs, PFDs, PFD responses, and other related documents, and the ability to search by issue, state body, coroner's court, legal team, experts, and so on. So I end by saying, please consider joining ILG. Consider supporting us and working with us. Lawyers are our ears and our eyes on inquests and the coronial system. We are strategic partners when it comes to scrutinising state-related deaths and improving the system for bereaved families. Thank you.
The Judicial Review and Courts Bill, a streamlined coronial system? In summer 2021, the Judicial Review and Courts Bill was introduced in the House of Commons to much controversy about proposed reforms to judicial review proceedings. Whilst the legal commentary was focused on that headline issue, less time was devoted to Chapter 4 of the bill, which proposes changes to the coronial system. These reforms are made by the government in a bid to improve efficiency in light of backlogs due to the COVID-19 pandemic. This particular talk explores the key provisions of the bill, the potential changes that may come about, and what else could be included to improve the coronial system. Turning to the bill itself. The most recent iteration of the bill was published on the 24th of February 2022, with 3 particular clauses being the focus of the bill, clauses 39, 40 and 41. Dealing with clause 39 first. Clause 39 will permit coroners to discontinue investigations where the cause of death becomes clear before the inquest final hearing. Currently, under the 2009 Coroners and Justice Act, an investigation can only be discontinued if a post-mortem examination reveals the cause of death. Clause 39 will fundamentally alter this. It will replace the preconditions to the power to discontinue from the need for a post-mortem to reveal the cause with a simple requirement that the cause becomes clear to a coroner before the inquest. This is a wide-ranging power of potentially unlimited scope, but with a dearth of strictures. It will allow coroners to take strident approaches to a range of different types of evidence and circumstances while applying a subjective view as to whether the coroner believes the cause has become clear, such that there is simply no need to proceed further. This, you may think, all appears to be in pursuit of efficiency. It is abundantly clear that in this regard, investigations may be terminated prematurely without witness evidence being tested in court or proper inquiries made into documentary evidence. As practitioners in this area will be all too familiar with, evidence commonly appears late and sometimes even during inquest hearings. Witness evidence, we all know, can change dramatically under questioning, and the scope of the inquest itself can change. Safeguards are clearly necessary to ensure proper investigation and scrutiny is possible where necessary, and the wishes of bereaved people are given weight. In recent weeks, Baroness Chapman of Darlington, the Shadow Minister of State at the Cabinet Office, suggested that Clause 39 be amended to provide that a coroner may not decide to discontinue an investigation unless A, the coroner is satisfied that there is no outstanding evidence relevant to the death available, that the coroner has considered if Article 2 is engaged, that there are no ongoing investigations by public bodies into the death, whether the coroner has invited representations from interested persons, and finally, all interested persons consent to the discontinuance. There are obvious difficulties with the latter issue of consent, given the coronial system is fundamentally a court that must make decisions even where unpopular. Systems that operate by way of consent are not, however, unusual in inquisitorial systems, albeit they may be unfamiliar in the adversarial world many practitioners often find themselves in. However, perhaps the most powerful draft proposal to appear in the House of Lords is that a coroner must provide provisional reasons for a proposed decision to discontinue. This amendment would ensure that certain safeguards are indeed met before a coroner can discontinue an investigation into a death, and that family members and personal representatives of the deceased are provided with the coroner's provisional reasons for why the coroner considers that the investigation should be discontinued, thus helping ensure that family members make an informed decision as to whether or not to consent to the discontinuation. What's more, a unique appeals process is proposed for interested persons who disagree with a coroner's decision to discontinue. There is no detail to this, including to whom an appeal would be made. Certainly, this is unlikely to help clear the backlog of cases, but may balance the rights of families more appropriately. As it stands, therefore, Clause 39 may in fact erode the circumstances in which inquests are held with scant few safeguards. The proposed amendments may, however, salvage much needed protections in this respect. Turning to Clause 40. Clause 40 provides a power to conduct non-contentious inquests in writing. This power, in short, can be used where a coroner is of the view that a hearing is simply unnecessary. Unlike Clause 39, there are safeguards built into this clause. A coroner is not to decide that a hearing is unnecessary unless 1a. The coroner has invited representations from each interested person known to the coroner. 2b. No interested person has represented on reasonable grounds that a hearing should take place. And 3c. It appears to the coroner that there is no real prospect of disagreement among interested persons as to the determination or findings that the inquest could or should make. And 4d. It appears to the coroner that no public interest would be served by a hearing. The organisations Inquest and Justice recently noted that the drafting of this clause does not make it clear whether a family's wishes would in fact constitute grounds needed to decide against conducting an inquest in writing. As many practitioners will be aware, a public hearing in which the coroner can answer questions and witnesses attend to answer questions is a central part of the coronial process. To this end, members of the House of Lords recently proposed an amendment to this clause, and this suggested that the coroner must seek consent as opposed to mere representations in order to hold the inquest in writing. Now, this amendment has yet to be added to the bill. Plainly, however, without more clarity on this clause, this new power and the drive to reduce the backlog may in fact undermine the obvious benefit of public hearings into deaths, as well as bereaved families' opportunities to understand the circumstances around their family member's death. Turning to Clause 41. Clause 41 deals with the use of audio or video links at inquests. Now, the use of technology across all courts boomed in 2020 with the imposition of lockdown and the need for alternative ways to keep the wheels of justice moving. But inquests remained unable to conduct these without coroners sitting in a courtroom, and consequently they commonly struggled to conduct jury trials without the juries being present in the largest courtrooms or indeed using the Nightingale courts. Clause 41 now seeks to remedy this situation. The clause enables inquests to be conducted either entirely or partly by way of audio or video links. The clause further permits juries to take part in a hearing virtually, albeit the jurors themselves must be present in the same place, such as an adjoining courtroom. This was the practice in some coroners' courts during lockdown and appears now to have been adopted as a good idea, as good practice. It is clear that technology must be utilised to better the coronial system. However, this cannot be at the expense of those unable to make the use of it, including those who would otherwise suffer great distress at having complex and sensitive inquests heard via a video link without the necessary support in place. Proposed amendments suggest this route should only be open to a coroner with the consent of the family, albeit this again encounters difficulties as previously discussed and highlighted. It would be expected that there would be provisions for the coroner to ensure representations are considered and the facilities available to interested persons, ensuring that they are addressed before electing to hold an inquest entirely by remote means. That is the current state of the bill as it passes through Parliament. The question must, however, be asked, are there other substantive amendments on the horizon? There are indeed two striking amendments proposed to the bill. First, in respect of suicide cases, and secondly, the question of funding. Dealing firstly with those cases involving suicide. The Lord Bishop of St Albans recently proposed that the coroners be permitted to record an opinion in cases of suicide as to the risk factors which were relevant to the death of the deceased. This amendment would allow coroners to record risk factors relevant in a death by suicide and requires the Secretary of State to issue guidance on the risk factors that the coroner must consider and the form in which the risk factors are recorded. For those who are involved in such cases, this can only be seen as a good and positive change. This will ensure public authorities, carers and families better understand, after a full inquiry into a death, what potentially led to that person's untimely death. Further, this may be of great benefit to public authorities in seeking to inform their safety mechanisms in secure environments. For example, in prisons and detention centres, we know there are frameworks that rely on the identification of risk factors in assessing the possibility that someone may harm themselves, and a focus on these factors can surely only help prisons and the need to better their systems and inform everyone. Care clearly must be taken in not overly prescribing and limiting the factors that may be recorded due to the complexities and very obvious sensitivities in this area. Nevertheless, this must be a very welcome change to the law. The second proposed amendment concerns funding for legal representation at inquests. The charity Inquest and others continue to call on the government to ensure that non-means tested legal aid is available for persons who have been bereaved and attend inquests where other government bodies, public authorities, and similar organisations are in fact legally represented. The case for public funding for bereaved people at inquests has been supported by a number of organisations. We include in that list the Parliamentary Justice Committee, the Independent Advisory Panel on Deaths in Custody, the Westminster Commission on Legal Aid, and 2 chief coroners. Many will be all too aware that families are often left without representation and set against expert legal teams defending the interests and reputations of the state. It is unavoidable, given the subject matter in many inquests, that legal professionals do their best for their client, which leads to robust defences and the narrowing of lines of inquiry. It is widely argued, therefore, and with great force, that this bill is an opportunity to end the inequality of arms for bereaved people at inquests. It remains to be seen whether the government will seize that opportunity and be brave enough to balance the scales once again. Now, an amendment to the bill has been proposed. Baroness Chapman of Darlington has sought to introduce provisions within the bill that state that bereaved people, such as family members, are indeed entitled to publicly funded legal representation in inquests where public bodies, such as the police or a hospital trust, are themselves legally represented. This may be introduced as an amendment to the Legal Aid Sentencing and Punishment of Offenders Act 2012. It is a proposal, you may think, that is strikingly simple and inevitably fair. It matches for a family the legal representation that a mighty public body may have. It is extraordinarily difficult, save for the reason of simply saving money, as to why this proposal would not be accepted. And ultimately, this matter is now in the government's hands. It remains, as I have said, to be seen, however, whether the government will back such plainly meritorious proposals or if the government will fail those who need legal aid in tragic circumstances. Thank you.
Hello, I'm Parissa Najah and I'm going to be giving a brief talk on legal aid in inquests. I'll start by just giving a brief overview of the usual position, which unfortunately, as many of you will know, is that people are likely to have to self-fund, or even in some circumstances, it's been known for people to crowdfund in order to be able to have legal advice and support throughout the inquest process. Legal aid is available in the form of legal help for the stages prior to trial in some circumstances, but I'm going to focus today on exceptional case funding and funding that's available for advocacy services at the inquest itself. Now, I think it's important that we do take some time to look at why legal aid for inquests is important. It's often stated that because of the relatively informal inquisitorial process that's involved in inquests, as opposed to the adversarial one that might be involved in a trial, legal aid isn't needed. But as many campaign groups have highlighted, there's often an inequality that's born when one party, and it's usually the family, isn't represented. And that's because public bodies such as the police or the NHS or others that may be involved are automatically funded at the public expense. A family member or family members may find themselves even facing several teams of lawyers that have been funded to support different public bodies at the same inquest, whilst they themselves don't have funding at all. The difficulty that raises is that inquests and their purpose really is to avoid deaths where possible, and where it's felt that the state may be liable for those deaths. It's effectively the family members that have the greatest interest in seeking that truth and preventing those deaths, whereas other organisations and state bodies in particular are often largely concerned, or at least in part concerned, with preserving their reputation. And it's for these reasons that campaigning is still ongoing to ensure that legal aid is more widely available, and available not only in the circumstances I'm about to outline. Helpfully, at present, the MOJ are undertaking a review of legal aid, and there's indication that they're going to extend their current funding so that funding for even early help is no longer means tested. Coming then to the exceptions that are in place to allow funding for advocacy at inquests. Again, as a result of helpful campaigning and persistent campaigning, recent changes have been made that mean that exceptional case funding for inquests is no longer means tested. Those changes were made through the Civil Legal Aid Financial Resources and Payment for Services Amendment regulations in 2021 and have come into force as of the 12th of January this year. The changes helpfully mean that new and pending applications for exceptional case funding no longer require a means assessment, and that existing certificates won't require any further contributions from those who have successfully applied. There's also a new submission form that's needed to be filled out, and only that form will be accepted from March 11th, which is important to note. There are two grounds upon which legal aid will be granted for representation at an inquest, and the first is that legal aid is required by Article 2. The second is where the director makes a wider public interest determination in relation to the individual and the inquest. Turning then to the first of those exceptions, which is the Article 2 exception. It's a two-stage test to see whether this will apply. The first limb of that test is that there is a procedural obligation which arises under Article 2. The second limb is where funded representation is required to discharge that procedural obligation that's arisen under the first limb. Article 2 confers a right to life and imposes on states substantive obligations both not to take life without justification and also to do all that could reasonably be expected to avoid a real and immediate risk of life, where the state knows or ought to know of the risk of a breach of Article 2. It also means that the state is to put in place a framework of laws, systems and precautions and a means of enforcing those to, again, seek to prevent death and protect life. An individual case will satisfy the first limb of the test, where on the circumstances of the case, a suspicion is raised as to whether either of the obligations on the state have been breached. Those are a real and an immediate risk that the state knew or ought to have known about, and putting in place the laws and systems I've mentioned. In terms of Article 2 then, there are some cases which automatically trigger Article 2. For example, intentional killings by state agents, including, for example, police shootings. There's another presentation by my colleagues going into detail about Article 2, which you might find interesting. The second stage of the Article 2 test then is whether funding is required to discharge a procedural obligation that's been established under the first limb. Now, it's very clear that in coming to a decision on this, the Legal Aid Agency must look at cases on a case-by-case basis. And the Lord Chancellor's guidance on this sets 3 clear areas that will be taken into consideration as part of this test, although of course these are not exhaustive. The first is the nature and seriousness of the allegations against state agents. For example, where deaths might be closely related, or there may be multiple unavoidable deaths coming from a particular state body or institution. The second is where there may have been previous investigations into the death. If that is the case, it's less likely that funding will be granted, although that's not a black and white position by any means. And of course, it's important at that point to note that in any application, if there are holes in previous investigations and, for example, family members haven't been able to participate fully for whatever reason, that's a matter that it would be very important to highlight. The third consideration that will be taken into account is the circumstances of the family. And that's really a broad brush consideration that takes account of not only emotional distress and mental health issues that might be suffered by family members, but also education level, any disabilities, any language issues. It's also key to note here that in terms of family members, where two family members have different or opposing arguments at an inquest, it may not be the case that both will qualify for the legal aid funding. That's a matter that was addressed in the case of R on the application of Joseph and the Director of Legal Aid Casework in 2015. In terms of completing applications for exceptional case funding, and especially where Article 2 might well be in contention, as well as including and specifically addressing those three issues identified in the Lord Chancellor's guidance, it's also important to remember the role that the coroner themselves can play. Where cases are complex or not clear on whether Article 2 is engaged, for example, coroners are able to properly take a view that it would be desirable, even necessary, for a full inquiry to take place, and that's without necessarily having to commit themselves to a view that Article 2 is engaged on the facts of the case. That's a matter that's played down to some extent in the Lord Chancellor's guidance, which states that very few cases would be appropriate for the coroner to state themselves that public funding would be desirable. But it's helpful to impress this point at this stage, is that it is proper, as I've stated, for a coroner to be approached where there are such factors in play that would make such an intervention desirable in order for the family to properly participate in the process. Factors a coroner might take into consideration include the amount of documentation that's involved, the complexity of the issues, not only legal but factual, the technical nature of the evidence, which is especially important where expert evidence is involved, as it often is, of a medical or scientific nature, which of course requires forensic analysis that may not be expected from a layperson. The existence of legal representation for other interested parties, which of course, as I've already stated, can mean that a family member is put on an unequal footing and set against other teams of legally represented parties. And finally, the relevant vulnerabilities of family members, and again that comes back to issues around their mental health, education level, language, and any other specifics that might arise in particular cases. I'll move now to talk about the second exception, which is the wider public interest exception. Section 10(4) sets out that the director can grant legal aid for excluded services for inquests, meaning advocacy, where the applicant qualifies for legal aid and the director makes a wider public interest determination. In order to fit into this category, it's important that significant benefits apply for a class of person other than the applicant themselves and members of their family. Often that means that it would need to be shown that any issues which the inquest is addressing are perhaps systemic, and we're not, for example, looking at a rogue individual within a public body, rather practices and procedures that are more widely adopted and therefore more widely have application. In terms of that wider public interest, it's stated that public interest must be significant, which really drives home that there is some hurdle to climb in terms of demonstrating the results that would be achieved or potentially achieved by funding such cases. And that's really what the guidance drives at. It's those tangible results. It looks almost for numbers in terms of how many people would seek to benefit and how that benefit would flow to them if the issues that the inquest raises are addressed. Importantly, cases that are of media interest don't automatically or at all satisfy this criteria, and there are important cases that have looked at this and have demonstrated that even where something perhaps has gained a lot of interest and been important in terms of media coverage, it doesn't mean that it will be able to satisfy this test and demonstrate the significant results in terms of benefit that the test requires. Again, under the wider public interest test, there is some account taken of other investigations, but I'll reiterate what I've already stated, that that's not a black and white matter, and it's absolutely necessary that if there are previous investigations that haven't been satisfactory, that point is addressed in any application. One case example comes in P and Secretary of State for Justice, which was heard in 2009. In that case, for example, there had been a death of an inmate in a prison, and it was found that the previous investigation, which had been conducted by a prison governor and a prison service area manager, wasn't sufficient, as those two individuals had been too closely connected with the development of the policy that the inquest sought to investigate. One can imagine very many similar scenarios where investigations might not have been conducted quite as independently as they could have been. I'll address a final point which is of note in relation to both exceptional case funding applications and the wider public interest, and that's urgency. It's a matter which is specifically addressed on the application form, and one which is important, particularly in some circumstances. In terms of demonstrating urgency, the question to ask is whether a delay would cause risk to the life, liberty or physical safety of a family. And so this is where, again, we're potentially coming into this wider public interest point and how others are affected or potentially impacted where there are systemic issues. And certainly if that is the case, there would be an argument for urgency. And that would mean that any application would be expedited, or certainly there's grounds to argue that it should be. I'll end my presentation there. Thank you very much.
Hello. Today my talk will be on reports to prevent future deaths, also referred to as Reg 28 reports or PFD reports. Statute, namely the Coroners and Justice Act, provides coroners with a duty to make reports to a person, organisation, local authority or government department where the coroner believes that action should be taken to prevent future deaths. The purpose of the PFD reports is not a punishment or laying blame, but to help society to learn from deaths, so of course they don't happen again. The Chief Coroner's guidance also envisages that the nature of the reports can assist families. And within that guidance, it states that the families will be able to say that their loved one's death was tragic and terrible, but at least it is less likely to happen to somebody else. Of course, that does not apply to all families. And from practice in the area, certainly some families do ascribe to that view, while others do not, and often take the view that it should not have happened in the first place. Broadly speaking, the reports should be intended to improve public health, welfare and safety. They should be clear, brief, focused and designed for practical effect. Turning to the making of the reports, the relevant provisions, are paragraph 7 of Schedule 5 of the Coroners and Justice Act 2009 and regulations 28 and 9 of the Coroners Investigations Regulations 2013. Turning firstly to paragraph 7 of Schedule 5, subsection 1 is that where a senior coroner has been conducting an investigation under this part into a person's death, anything revealed by the investigation gives rise to a concern that circumstances creating a risk of other deaths will occur or will continue to exist in the future, and, in the coroner's opinion, action should be taken to prevent the occurrence or continuation of such circumstances or to eliminate or reduce the risk of death created by such circumstances. Then the coroner must report the matter to a person who the coroner believes may have the power to take such action. Turning to the explanatory notes of that section, an example is given of a PFD, and that is in the instance where a senior coroner reports to the local authority the fact that several deaths have occurred in similar circumstances on the same stretch of road. The PFD process is ancillary to the inquest procedure and it is not its mainspring. However, in an Article 2 inquest, it may complete the state's duty to inquire fully into the death. However, it is not mandatory simply because it is an Article 2 inquest. Turning then to the definition of giving rise to concern. This is effectively the triggering of the duty. And that is that something has been revealed by the investigation. And by the investigation is an important term because it is not just limiting it to the information that has been heard during the inquest. It isn't the investigation as a whole. And that something in that investigation gives rise to the concern. The coroner, as I've already indicated, is not just restricted to the points that they have heard evidence on, but the entirety of the investigation. Giving rise to concern is a relatively low threshold, and the concern is to the risk to life caused by the present or future circumstances. As already stated, this is not restricted to the matters which are causative to the death under investigation. One example might be prison cell bells. Now, I'm sure as many of you know that on the prison wing, there are cell bells in each of the cells. And they work by triggering both a visual as well as a noise alarm. So when they go off, it will come up on a board so the prison officers can see that that specific light is illuminating. However, it will also sound. Now, in the inquest I did, on the day in question, the cell bells were not sounding appropriately. And although they had been reported to the maintenance team, nobody had been to fix them. Now, the failure of the cell bells in that specific case had no causative effect upon the individual's death. However, as you might imagine, they could be crucial in relation to another death, as those cell bells are primarily used when somebody is in distress. A further example taken from the Coroner's Guidance number 5 is involving a suicide. And the example being that somebody has committed suicide at home and firearms are found in their house. It is known to police that the deceased has a history of serious violence and questions are raised during the course of the investigation about police checks made for the purpose of firearm certificates. These questions raise sufficient concern with the coroner that action should be taken to prevent future deaths. Not the death in that specific circumstance, but relating to other possible deaths where police checks about firearms are shown to be inadequate. The coroner can also make reports to national government bodies, but only if the matter has been fully explored during the inquest or investigation. Again, taking another example from the coroner's guidance number 5, that being say that the coroner hears evidence that an operation has resulted in a death. The surgeon then gives evidence at the inquest that as a result of this, there is now an addition to the sum of medical knowledge that could improve surgical outcomes in the future. Bringing this learning to the trust's attention, both regionally and nationally, by way of a PFD, may be entirely proper. However, if a witness mentions something in passing which has not been explored at the inquest, the coroner should be very reluctant to bring it to the regional and national body's attention. Turning then to the timing of a PFD. At what time should this be considered during the inquest? Regulation 28 subsection 3 states that a report may not be made until the coroner has considered all the documents, evidence and information that, in the opinion of the coroner, are relevant to the investigation. Naturally, that would suggest that the PFD process should take place at the end of the inquest. Taking from my own experience, during each inquest I've done, this process has been undertaken at the end and usually involves the coroner recalling certain witnesses to hear evidence specifically on PFD points. And usually those individuals have managerial positions, think such as the prison governors, the head of healthcare in prisons, or high-level police officers or sergeants who have management responsibility. It is primarily for them to answer those questions rather than the nurses or doctors or police officers on the ground. I have also experienced 2 different ways in which this is conducted. Firstly, that evidence of PFD is heard in the presence of the jury. Alternatively, that this process is undertaken while the jury are considering their conclusion. Although, per the coroner's guidance, it seems that the former is preferable, as the guidance states that all relevant evidence regarding the death should be heard in front of the jury before the coroner sums up and directs the law. Therefore, seem that really it should be in front of the jury that this evidence is heard. Turning to timing once again, although at the end it may be the natural place to hear the PFD evidence and make such report, this is not a hard and fast rule, and it can take place at any time as long as regulation 28 subsection 3 is complied with. Moving on then to evidence. The focus during the evidence is on the current position and what has changed since the time of death. Usually, particularly in Article 2 inquest, there is a considerable time between when the deceased passed away and then when the inquest is heard. And this can often be that contracts have changed. For example, the prison may have a healthcare contract with one company, but during the interim, that contract has gone to a different company and the management has changed as well as the rules and procedures. It can also be that during that time, without prompting from the coroner's court, considerable changes have been made. In terms of what evidence can be heard, this is not restricted to evidence concerning the statutory questions to be answered, but concerns all the evidence relevant for the consideration of the PFD reports. Also, it is not necessarily that the individuals given evidence are required to say this has changed since the death. If, for example, new evidence comes to light during the inquest in which, take an example, the prison were not aware of, they could say to the coroner, having heard this evidence, we have discussed this point and these steps will be taken to remedy it. That can often be satisfactory for the coroner. It is the coroner's opinion which matters, and having heard the evidence, as well as submissions from advocates and points, the decision is for the coroner alone, on a case-by-case basis, taking into consideration all the circumstances. And it is usually this point which is the stumbling block if you're seeking for a PFD report. Usually there is sufficient evidence to raise the concern, but often, particularly in cases where there has been a considerable time since the date the deceased died and the hearing of the inquest, many things have changed, and usually the coroner is satisfied that the relevant steps have been taken and therefore no PFD report is required. Turning to then what should be included in such a report, there is a template which is annexed to the Coroner's Guidance number 5, and it is that template that should be used by the coroners. And that includes the coroner's concerns, which should be set out in a neutral and non-contentious manner, in which the factual basis for each concern is set out. We must also identify who the coroner believes has the power to undertake the required changes, either the person's name or the organisation. Then the recommendation that action should be taken to prevent future deaths. It's the coroner's role to identify the points of concern, not prescribe the solutions. Effectively saying that this issue needs to be fixed or recommend that such procedures should be reviewed. But it's not the coroner's role to say you should do X to achieve Y. For example, it may be that there is only one way to fix a concern. However, often there are multiple different ways of achieving the same outcome, and that is a matter for who receives the report rather than the coroner. Turning back to paragraph 7 of Schedule 5, subsection 2. A person to whom a senior coroner makes a report under this paragraph must give the senior coroner a written response to it. And then subsection 3, a copy of the report under this paragraph and of the response to it must be sent to the chief coroner. When a report is made, that is to be sent to all the interested parties. If the deceased was under the age of 18, a copy should also be sent to the local safeguarding children's board. In terms of the chief coroner, it is for the coroner to publish the report on the courts and tribunals' judiciary website. This is not a must, it's a may, but often this is done. As well as any PFD be included in the annual report that the chief coroner gives to the Lord Chancellor. Once it has been sent, referring to the sending of the PFD report, there is no power to withdraw it. The appropriate remedy for correcting mistakes of fact is by responding to the report. The person who receives the report, namely the person named as having the power or the organisation or local authority, is under a duty to give a response, and the relevant provision for that is Regulation 28. The response must be provided to the coroner within 56 days, on the date from which the report is sent. The response must contain details of any action that has been taken or which is proposed to be taken in response to the report. If the decision has been made not to take any action, by the person receiving the report, that should also be explained. The response that the senior coroner received should also be sent to the chief coroner. Finally, then turning to publication of reports and responses. It is inherently in the public interest for these reports to be published. However, there may be rare, compelling reasons not to do so. When publishing reports online, there are certain things in which it is advisable not to be included. Really, these reports should only contain the name of the deceased person. They should not contain any names or personal details of other people involved or case reference numbers. Interestingly and rather logically, what should also not be included in these reports online is information that could help somebody to cause a death, including if death has been caused by substances, the name of that substance, the amount that they have taken, how they have got that substance. If we're thinking suicide, if that person has watched any videos or visited any websites up until the point of their death, which provides a step-by-step guide, or namely any specific suicide spots. The report should also redact any information necessary for the public interest or to protect other individuals. However, the coroner may choose to include any of the above. To remove it would be detrimental to the public's understanding of the learning in a report or response. Also, persons of interest in the inquest, as well as the organisations in local authorities or persons which the report has been served on, are entitled to make representations to the Chief Coroner about the decision to publish, the form of publication, whether it is summary or full, redactions, or any other relevant matters. And that concludes my talk. Thank you.